We've got a lot of information to go over, so we're going to go through the slides fairly quickly, and I know y'all know how to read, so you can go back and review it after the presentation. And please hold all your questions until after the presentation. We'll be glad to take as much time as we need to after the presentation to answer any questions. So anyway, we're going to go ahead and get started. Our presentation is on transition planning, tools and tips for special needs older youth. Okay, and these are basically the four areas we're going to be talking about. And we're going to start out with older and younger youth as well. The criteria for meeting SSI eligibility for children under 18, and basically your child is basically compared to, they gauge that child's ability to perform age-appropriate activities compared to children of the same age without impairment. And it lists some of the common disorders that you'll see there with the children. So, and you'll get a lot of these cases where they need a SSI or SSDI application filed. It usually takes 2 or more of these disorders to get qualified. Okay, let me back up. Who in the audience can tell me what the criteria is, what you have to prove to get approval for adult SSI? In the front row?
That one or more of your major life activities is affected by the disability.
Right, that's part of it, but what does anybody know what SGA stands for? SGA, another acronym in dependency court? Okay, we'll go on. Basically, it's a different standard for an adult Social Security disability application. You have to prove that the disability, it's really an inability to engage in any substantial gainful activity. That's what that stands for. That's the standard for the adult applications. And basically, SGA is defined as earning $11.70 per month or more. So if they make more than that, they're probably not going to get approved. And it's a harder standard to prove. So you'll have some of your kids who easily got approved for child benefits, and they're filing their adult application 3 months before they turn 18. So you want to make sure you get those filed if they haven't been filed for your child or your child that's getting ready to age out. And you're also going to want to work with your medical providers and people evaluating them to do these, to submit a report to Social Security. And what I like to do is intertwine this language, the SGA and the standard, into those reports if your medical provider feels that honestly they live up to these Social Security standards. And most of your medical providers are familiar with these standards and will incorporate them in the child's report to get a hopeful approval as soon as possible. So anyway, it's really important. Some of my kids aging out that have had the SSI through childhood, it's really going to impact them if they get denied as an adult. And you may also consider them hiring a Social Security disability specialist. I think like Mary Kay was saying, they work on contingency, like 25% of back benefits due, and up to a certain amount. I think it's around $6,000, but the attorney can still petition for more. Okay, and this is just basically going over tactics you can use to try to get these medical evaluations done, email, talk with them, tell them what you're looking for, what you need. Of course, their professional opinion is up to themselves. Oh, here's a problem I had in a case with a SSI app. It had never been applied for, and it was filed right before he was 18. He's still in extended foster care. But anyway, he was in jail, and all the correspondences from the Social Security Administration were coming to his group home and not to the extended foster care CBC. So he got denied and nobody knew about it, so he's going to have to start back from scratch. So make sure they're in the loop and they're getting duplicate notices as well. Okay, and y'all probably know this, the CBC Master Trust terminates when your child turns 18, and someone else has to become a Social Security payee. Either your child, either your young adult, and that's usually not good when they're special needs, or a third-party designee. And many of the placements require the payee to be a third party just to ensure payment. Okay, this slide talks about what is APD, that stands for Agency for Persons with Disability, and this gives a little background of it and what these Cadillac services are for these special needs children. It's called the Medicaid Waiver Program, and it's run through the state. I guess the federal government has waived their right to administer the program, and they're delegating that down to the state. Children in DCF custody have priority over almost everyone else, except for people in major crisis situations, homelessness and the like. So, and they'll keep this priority classification until they're 18 and older. Now, when they get approved, when that APD application is filed and they're still under 18, and they do get approved, they're going to be put on what's called the Med Waiver wait list. And you're like, well, if they're on a wait list and we got all this trouble, what good is that going to do them? But there are a lot of great benefits on the wait list. And I go over some of them here. I've got special needs children under 18 in really nice APD group homes if there is a vacancy. They provide many services for them. I've got one girl in an APD group home, and she's got her behavioral case analyst, and her case manager is with her around 30 hours a week. So it's just a great program to help with these special needs. Now, you can read this statute, and it was confusing to me, but the bottom line about the children coming out of foster care, moving up to a crisis category 2, I have spoken with the APD representative in my region. And basically, what he's telling me is that all children aging out of foster care or extended foster care or getting into a permanent home with family members or going into extended foster care, they're going to go to the full waiver services and even get additional services if they're in extended foster care. You can read about it there. So kind of disregard that category 2 waiting list. That isn't what really happens. Now, if the children go into extended foster care, they get contributions for services from the CBC and from APD, which is really good because APD doesn't cover everything. So I have one child that wants to go to a summer day program academically, and APD doesn't cover that. So the APD coordinator and I have reached out to the CBC to contribute on this. You know, APD, when they're providing services, do so much. That's the very least our extended foster care CBCs can come in and pinch hit as long as the services aren't duplicative. Now, also notice under the statute, you can read more about this. I'm married to a military guy. That APD grants children of active duty military service members the right to receive those benefits under certain circumstances, and you can read about that more there. I think it's moving into state. Now, after it was the rule for a long time that when the older adults are getting ready to turn 18, and they're on the APD wait list, the case managers and all the parties would have to collaborate and fill out this kind of complex crisis tool packet to submit to APD. Now it's a much simpler process. When the youth leaves DCF custody or ages out of foster care or they age out of extended foster care, the case manager simply submits to the local, when they get ready to turn 18, they just send a form over to the APD regional office, and they take care of the rest and go ahead and get them enrolled on the full waiver services. They're not on the wait list anymore. They do go to that higher Cadillac service. Okay, I think I've already discussed this. I've already talked about that. Okay, who specifically qualifies for APD in Florida? We go through the criteria for that there. Have to be at a certain level of care in an intermediate care facility for developmentally disabled persons, and med waiver services must be needed for the person to remain in the community. If you get denied, you can also appeal. Oops, I got to go back. I got another question. Okay, who can tell me one or more of the designated developmental disabilities you need to qualify for APD? In the back there?
Autism.
Very good. And you?
Cerebral palsy.
Very good. Anyone else? Very good. Anyone else?
William Prater syndrome.
That's it. I had one. Yeah, well, in a separate guardianship. I had it. Finally had my first one. Okay, very good. We got plenty of candy. I hope y'all are hungry, so pass it out. Thank you. Okay, these are the 7 categories that has to be substantiated for the APD qualification, and you'll see those there. So important that one of these disorders or syndromes must manifest before the age of 18. You've got to get these evaluations done and the proper protocol for them before they turn 18, or it's too late. And you're basically talking about long-term adult benefits that this person may be eligible for. It's just such an important thing. If you even suspect one of these categories, please pursue it. And it has to constitute a substantial handicap that can reasonably be expected to continue indefinitely. Now, when you look under the administrative code, there's a specific protocol testings for each of these disabilities. And go there, like for the IQ testing, there are 2 parts to that. And then it goes through what they accept as some of their accepted testings, like the Stanford-Binet, for example, and the IQ testing. And that has to be under 70. These are some more of the benefits that the APD our Florida APD provides. And it's just amazing to see them at work. And their in-home support services are really great, I cannot tell you. And their ABA teams that I've seen in action are great. And like I said in the other presentation, the APD groups, I've been impressed with them in our area. Okay, this is just kind of going back through your analysis of what you need to kind of look for in starting that process. And sometimes you'll get in the case and then you ask the case manager, is this person on the wait list, on the APD wait list? They have no idea. So you need to research it. apdcares.org, go to the website and contact your local office, and they'll be real good to look it up and tell you. And they've got all kinds of community support people, the housing people, everything. Really great to deal with. Okay, you're under a time clock to get this done, and you may have to go to your CBC to get the APD evaluations, to ask for a purchase of service to get a specific evaluation, to hopefully get your APD application approved. And even with my providers, I email them a copy of the statute. You know, they do this a lot, but then they kind of interweave in their professional opinion, you know, with the statutory necessary language, so that helps too. Now, I have also been appointed to some to one in particular, a post-18 young adult in extended foster care who was in DCF custody for many years. And there were never any specific testings ever done to try to get him qualified for APD services. So we do have some corroborating documents from before when he was 18, school record, CBHA for intellectual disability. But in this case, we'll see if it works. You gather all the collaterals you can from before they were 18, school records, behavioral things. I'm trying to go back through every psychologist he was under before he was 18. But I'm also have requested and got court approval for a local psychologist to look at his IQ now and to determine if it was that, and his professional opinion, he's going to be able to say what it was, you know, absent any head trauma or whatever, that it is at least that low, or was at least that low before he turned 18. So I call that the kind of a look back, retroactive approach to that. And that's the best I can do at this point. So, okay, now we're going to talk about fee waivers, where you go into a child's master trust and ask for funds to come out that are justified for your client, would benefit your client. it's just an awesome, when I first learned about this, I was like, oh, yes, we can go in and raid this child's Social Security monthly funds, for a long period of time. It's just a great process. So basically, the CBC is waiving their rights to get reimbursement for home and board and that sort of thing. And every foster care child is entitled for fee waivers to be done for them. It's just wonderful. And it's not that complicated of an ordeal to make a fee waiver application for your client. There are forms, and you're going to submit that to your CBC client trust fund specialist. And then they're going to review your packet, then they're going to schedule a conference call meeting on the fee waiver. And I always just appear by phone, and I have my client, if they're old enough and able, competent to appear on the phone as well, just to corroborate the items that are requested. You can also appeal that. Here's some of the forms that you have to fill out. Okay, and what are some of the things authorized? Clothing, recreation, electronics, therapeutic equipment, living and some medical expenditures if not otherwise provided or paid for by Medicaid, and some payment of cost of residential care, I guess, or maintenance fee if your CBC is not obligated to pay it. Now I have some questions. Who can tell me and SSI has some income asset restrictions to it. Who can tell me what currently that restriction is? What's the most you can have?
It's $2,000 in bank, no more than $15,000 in garden burial benefits. You're allowed to have a car, a home, and I don't know what else I'm
Oh, you were so awesome. Yeah, that $2,000, you got it. If it's $2,001, that's too much, so that's awesome. Yeah, give her 3 pieces of candy. She really knows her stuff. Okay, now who can tell me, if you file this fee application, what part can you not ask for a fee waiver on? Does anybody know the answer to that? There's a little part of that you can't encroach. Okay. Who said that? What'd you say?
It's their little, their monthly, allowance.
Bingo! You got it, thank you. That's part of it. So if that child's receiving $735 a month, you can only ask for a fee waiver on the $705 a month. Who can tell me what period of time in the future can you ask the total fee waiver to cover? Does anybody know? Okay, that would be for 12 months. You can go 12 months out per one fee waiver, so that's awesome. Okay, and I go into some of this for kids getting ready to age out. And what you want to try to do, you want to start looking at that master trust when it hits 1,200 or above, because if it gets over 2,000, anything above that's going to be forfeited. So you want to keep that balance, closer to 1,200 at all times or below if you can, because if that balance gets up above that, it's gone. You want to try to conserve funds as much as you can when they turn 18. Now, if it's an SSI master trust, that's only up to around $2,000. I know the Sixth Circuit will go a little bit more. Now, if it's an SSDI trust, as non-SSI, you can conserve as much as you want to, as much as you can if your child wants to. Can't waive that monthly. Can't ask for a fee waiver on that $30 allowance. I've already. Okay. So you always want to be thinking about, when I meet with a child, what kind of fee waiver can I ask for my child? And be creative to think of all the possibilities, a lot of different things, and I'll talk about them here. And your older adults, I'm telling you, you just keep your supporting documentation handy. It's all the cell phone service, laptops, fit watches, toiletries, clothes, that sort of thing. But think about them aging out and help them plan for when they're going to be over 18.
I have a question back here.
Yes.
Sorry. So when a child is aging out or reaching permanency, the money that is in that master trust, that if it's close to $2,000,
Well, we're going to talk about that. If you get that the order dispersing the funds to the child, it won't go back to Social Security. They can go down to the office and pick it up directly. When I'm going to talk about that order. Yeah, that's very important.
Incremency, if you're not.
Yeah, same thing. It would be the same thing, so. And the pay, whoever that is, would come down. And then they don't have to wait that long time for it to, if not, it goes back to Social Security and they hold it, but then you'd have to do a reclamation process to get it back. Yes, ma'am?
Okay, so I understand about the SSI and the asset limitation, but, how would the master trust work if somebody who's like an asset protection type of vehicle, such as a special needs trust for the AU account?
Right, that would not offset it. We're going to talk about that just a little bit. Yeah, in just a second. And interestingly, I know I was talking to our master trust specialist, and she said even foods for special diets, if not covered by Medicaid, specialized transportation, if it's not covered somewhere else, paint therapy for your autistic children, trip expenses, normalcy costs. It's just anything that a normal child would enjoy doing. So a lot of my teenagers, the state attorney, my DCF attorneys are so jealous because I get them the best iPhone 7 Plus. They're like, I don't even have that. I'm like, oh, well, she's on the run a lot. We got to have good equipment for her. So now it will not cover the cost of medical or mental health evaluations or examinations, but it may cover any recommended therapies and treatments, if not covered by insurance or another place. Now, oh, yes, sir?
The little bit I've tried to do this, I was told that you had to be very specific on what you want the money for. I couldn't just say furniture for their apartment when they moved. They wanted to know what couch.
Right, from IKEA, and what are they getting? Yes, and they do want that. So that's we'll get to that a little bit further.
Much ahead of time.
Yeah, and then I've had the thing with my kids aging out where it would be a storage fee cost as well. So in a way, it kind of turned out to be very practical for them. But I haven't had any that have had free storage. So, and we'll talk about that a little bit more. So anyway, you're also going to want to investigate to see if there are any sub-accounts that hold any lump sum retroactive funds. They're going to be held in a separate account. They're usually designated by your master trust people. They do not offset. They're already set up, and they will not be offsetting that SSI, $2,000 asset limitation. And here are some of the ones you see. And also with these big lump sum trusts, you can draw out of them like a pass account for special designated needs, like vocational needs and stuff like that. So, and I've attached for resource information the master trust operating procedures, and it discusses in detail these. But usually you see them if they're already set up there. They're already SSI. They won't affect it. So now one of these accounts, which is used as called one of these sub accounts, is called a PASS. A sub-account, and it stands for Plan to Achieve Self-Support. Basically, it's available for foster children 15 years and older, and they have to submit a PASS plan and get it approved. All the forms are on the Social Security Administration website for a specific vocational need, and if you go to their website, you can read what qualifies for that. And what this is good, it's not concerning. You can't take funds out of their SSI Master Trust and put them over to this. But it's basically for third-party funds, like you've got a teenager who's working part-time, and there isn't a very big exemption for that. It's like the first $65, then half of their earnings. So the rest of that they could put in this sub-account and shelter it, so it wouldn't decrease their SSI benefits. Reach out to charities, local businesses to donate when you can. They want to do things for these special needs kids if they can. They've been very receptive, and they get a tax write-off. Okay, now we're going to quickly go through a sample of the fee waiver request for the older youth. My husband kids me. I kid my husband, I should say. He's got an old bass boat, and when he wants something new for it, I'm like, you got to do a fee waiver request for that, so we think that's kind of, because he sees me at night working on these sometimes. So, okay, and this is a sample cover letter I've sent for a fee waiver request, and you go through the analysis, what you want, the cost, sales tax, shipping, the priority of how you want it to come out. If they want that cell phone first, You want that to come out of the first 703, and then they want the watch next, that comes out of the next. So you gotta give them the priority there. You also gotta tell them that you'll be seeking to conserve any leftover funds, and we'll be seeking an order to have those dispersed directly to your child when they turn 18 or to the payee. And you can read that later. Here's a notice of fee assessment and rights of foster child. You're probably seeing these filed for the judicial review, so that has to be filled out by you. And here's that accounting you see filed with the court. But I always just, they're kind of hard to figure out. I always just call my master trust. And plus, usually these are old. When you're reviewing, get an updated one, or just ask your, go over the details with your master trust specialist in your circuit or in your county. Okay, here we go. Yes, and somebody said you have to be very specific. This iPhone 7, I just printed it off online and include sales tax, any shipping. But I do that for each thing. It's like the price. It's fun. It's like the Price is Right. You get to say, hey, I want to spend all this money, and this is how I want to spend it. Now, the Sixth Circuit, they want you to do in Excel a budget for everything, and it is very detailed. You know, cell phone service for the next 12 months, these other things. Now, clothes and toiletries, they're not that specific on. In the Sixth Circuit, they also have an Amazon wish list. They've got certain vendors that give them good deals, and you can just go directly to Amazon from the CBC, so it's really wonderful. And that's giving you the total and how long you're asking for it. Okay, and you can amend your fee waiver request before your conference and even at the start of your conference. I've done that. I was confused. I had one account, rarely see these, that was a SSDI instead of a SSI, because she emailed me back. She said, that's not a SSI account. And so we could conserve more before she turned 18, which we did. She went back. She said because I can conserve more than $2,000, she reduced her wish list, so to conserve more. Okay, here's that order to disperse, conserve master trust funds upon the child's 18th birthday. If this order is not entered, like I told her, leftover funds are going to be returned to SSA, and youth will have to reclaim them there. So this is nice. They can just go down there. They and their payee, or if they're the payee, they can go down there when they turn 18. Okay, y'all are probably familiar with this. It's the right of kids aging out of foster care, or any children that are in DCF care when they turn 18, and some other examples when they're 16 and have spent more, when they go in after spending at least 6 months in the custody of the department after reaching 16 years of age and were later placed in a guardian. All these people get a free ride at tuition in the state of Florida, which is wonderful. For different, and there are different post-secondary education programs that qualify for this, and you can read about that there. If your child qualifies, you're going to want to get that order entered, and the judges are glad to do that. You can have a hearing on this. I'm a Georgia Bulldog, so it just pained me to put these in here, but I'm in Florida now, so I have to. Okay, there's another example there. Okay, we're going to talk briefly. How am I on time?
Good, you got 10 minutes.
Before the 30 minutes is up? Okay, great. Okay, how many of you are familiar with the motions and orders to remove the disability of non-age? Who's done those before? Oh, I've got such a qualified group. These are great. They were basically going to emancipate specific rights for your children before they turn 18 to get things done to help them with independent living. Who can tell me what are some of the specific areas you can move for the removal of the disability of non-age on? What specifically is under the statute? Okay.
Lease agreements, utility payments, financial accounts.
Okay, she could give the program, I tell you. Thank you very much. If you want to give her-
No, we can.
And by statute, these have to be separate orders. They can't be in with the JR or anything. And you have to show that they're in the child's best interest. And as they get up 15, 16, 17, you're going to want to look at these things. Okay, first one, they can obtain a bank account. This is great for your part-time working, even my special needs teenagers. A lot of them work, especially on the psychotropic medication. Have to be 16, and they have to complete a financial literacy class. And the one I had, it's very liberal. I think the only testimony was she had talked with her case management manager about budgeting or something. So that financial literacy class is not a big hurdle. The one permitting the child to go ahead and sign a residential lease for that to start upon the child's 18th birthday, they can do that at 17. The one for the utility services to go along with the lease. And I usually address the lease and the utilities in one motion and proposed order, and that's fine for those two specific areas. Now, here's the removal of non-age for motor vehicle insurance. You have to be 16 and have completed a driver's education program and an out-of-home placement. How many of you all have done this for a special needs child? Any? I haven't done it for any of mine. I may for some of my special needs and extended foster care, though. But I haven't seen it, you know, it's just, it hasn't been an issue for them, so. Okay. Now, who can tell me the name of the program, the independent living program that will pay for the cost of a learner's permit, driver's permit, ongoing insurance, and and deductibles even? Oh, y'all are so good. Okay, here's the skinny on this, and their website's fantastic. It's a program for reimbursement for these things, and they'll pay up to $200 monthly for the car insurance premium, reimburse them, and up to $1,000 for per accident deductible. It's great. And according to the website, that's all good, and we'll cover them, I guess, all costs between 15 to 21. You have to meet the DMV requirements, have approval from their primary caregiver, and that may be possibly their parents if they're not terminated, complete the documentation. And this was very interesting. If they're under 18 and above 16, and Florida has a special car insurance program through the Florida Automobile Joint Underwriters Association, you don't need that order removing the non-age disability for that company. For the other ones, you will need it, so may want to check with them first. Okay, extended foster care. Ooh, let me go back. Who can tell me what's the latest a child can stay in extended foster care? Anybody else? She's answered so many.
It depends on the child.
Okay, how does it depend on the child?
Whether they have a disability or not, that prevents from engaging in a qualifying activity.
Okay, so for a non-disabled child, how long can they stay in? Okay, got 21. For a disabled child, how long can they stay in?
22.
Got it. Okay. Anyway, the children living in the licensed care, who is eligible for this? Basically, they have to be in a licensed foster care when on their 18th birthday and have not achieved permanency otherwise. Those are the only ones. So that's that key date when they turn 18. And this is such an important right. And now, if you're person, and there's certain requirements to stay in it for non-disabled young adults, and you'll see them there staying in the secondary education, working a certain number of hours, being in a vocational rehab. Now, if they are, like many of our special needs, if they're unable to participate in these programs or activities, they won't be required to do that, and you can read about the statutory language there. I actually had a child who was very troublesome, and the department filed a motion to discharge them out of the program, and you can raise these defenses.
Question, if the child's on runaway status?
Well, hopefully if they come back, yeah, because if they're not able to come and attend the hearing, eventually that judge is going to grant that motion to discharge. But this child was on the run a lot, which is why they wanted to discharge him. But, hey, you got this defense under this, they're disabled and unable to participate. It shouldn't matter if they're on the run or not. That would be my argument.
And if they're on runaway status while they're supposedly in licensed foster care, but they're not in licensed foster care because there's no beds because they're in runaway status, do they still qualify?
I believe so.
We've had judges say yes.
Yeah, that they would still qualify. Yes.
Still in custody of DCF.
And the runners, they're the ones they're going to want to discharge, so you can raise, their disability, they're unable to participate or maybe incompetent, what have you. And they're supposed to live independently here. Now, and just explain to them as well, big thing, just get them make sure they're qualified when they turn 18, explain to them they can opt out and opt back in at any time. But, you also need to explain to them what might be involved if they opt out and opt back in. They may be a big hassle and have benefits suspended or something. And this is the standard for them opting out, that they knowingly and voluntarily withdraw his or her consent to participate in extended foster care. So if you don't think that they satisfy that statute, and a lot of them don't. I had one in a psychotic state brought over from the jail who wanted to opt out. I had to advocate for it, and then the judge said, this person's incompetent. They're not able to opt out. He stayed in extended foster care, wanted to stay. He was the one that then they filed a motion to discharge him out of the program for not doing the thing. So I got to go back and argue his incompetency, and basically he was basically unable under the statutory criteria to even make an opt-out decision, which helped him, and he's doing well in extended foster care. So explain to them that this is a safety net, because some of them are like, they can't get their head around that concept of opting out, opting in, opting out, opting in if they wanted to. Now, I've had some of my children, right before they turn 18, the case managers and people get with them, and they're like, you don't want to stay in that. And they get them to sign a waiver of that. It's really strange. And then I counsel them, and they're like, all the great things about, or they're like, well, they're at good APD services, so they don't need to stay in extended foster care. And so I counsel them against that, and I'll go back, and if I think that there's something in their file or something signed by their saying they don't want to stay in foster care, I get them to sign something saying they intend to stay in foster care. Very important here, when they're getting ready to turn 18 and they're saying, I don't want extended foster care, I don't want to participate, you really need to have your judge or magistrate examine them on the record to make sure that's a knowing and informed decision. Because I had one case, it was very interesting, a foster child who went back 2 weeks before she turned 18 with her adoptive parents, who she had a very tumultuous relationship with. And I explained all this to her. You're not going to be eligible if you go back with them. Can you not wait a couple weeks to go back in with them? No, she couldn't wait. I get a call 2 months later. She's kicked out of the house. This an ex-foster mother's calling me saying she didn't understand what she was doing when she went back home with her parents. So it's going to be on you. So you have this voir dire examination and have that hearing in front of the judge have them sign something. I think I've discovered this. And remember, it's important that they have attorney ad litems when they're in extended foster care, because these issues are coming up all the time. All right, and then some of these youth coming in, getting ready to turn 18, they're like, well, I'm gonna go back with so-and-so, relative, cousin, whatever, and it never worked out before. And you're just like, well, consider this as a safety net if you need it. So just encourage for them to get back into foster care right before they turn 18, or stay in foster care at least until that time. Okay, here's a letter and statement I did for one of my clients who presented in court, just reciting his intention. All right, and I'm gonna turn it over to Ms. Price. How are we on time? Good. Okay.
Okay, thank you, Baldry. That was excellent. And can everyone hear me? I'm going to be covering some of the statutes, and that always helps in your argument in court, is to refer directly to the statute. You already know that. The Road to Independence Program, Section 409, 1451, the legislative intent is for young adults to receive the skills, education, and support if they so choose, and develop a lifelong connection with supportive adult through Road to Independence Program, through post-secondary education or aftercare services. Florida Statute Section 409.1451(2) is PES program, or Post-Secondary Education Services and Support. It is an option only for those who have high school diploma or GED You must be living in licensed care on your 18th birthday and previously spent at least 6 months or in licensed care, or you were at least 16 and were adopted from foster care or placed with a court-approved dependency guardian after spending at least 6 months in licensed care within the 12 months immediately preceding such placement or adoption. I believe that this section should be expanded, so my tip is to write your legislature and include more foster kids. I have a foster kid right now that is going to have her possible parental rights terminated, maybe. And she was a foster child. She was only in foster care for 2 years, so she wouldn't qualify for this. So then when she got out, she basically had a lot of financial problems, a lot of children, no care, no aftercare services. PES continued, you must be enrolled a minimum of 9 credit hours, and it's equivalent in an eligible post-secondary institution, and those are in the statute what qualifies as that of those institutions. A student may enroll part-time if he or she has a recognized disability or is faced with another challenge or circumstance that would prevent full-time attendance. So that's going to be a lot of your young adults. And tip number 3 is just that the majority of the young youth that you're representing are going to probably fall in this category. A student needing to enroll part-time for any reason other than having a recognized disability must get approval from his or her academic advisor, and that should be pretty easy to get. They're probably going to want to cooperate and help your child. PES continued. The child has reached 18 but is not yet 23 years, has applied for other grants and scholarships which may qualify for with assistance from caregiver and community-based lead agency, has submitted a FAFSA. Who knows what FAFSA stands for? Valdry did not know.
Financially,
But what does it, what are
the
the,
letters.
yeah. Anybody know? If you have kids, oh, go ahead.
I think it's federal financial student aid.
Close. Free application for federal student aid. And also have a signed agreement allowing the department and community-based lead agency access to school records. PES continued is going to be $1,256 monthly if not in foster care and is attending a post-secondary school. Again, those schools will be listed what qualifies as a post-secondary institution. Or you've remained in foster care at an established room and board rate for foster parents if the young adult resides in licensed foster home and is attending post-secondary school. Don't forget to counsel them on this issue. It's rough out there. $1,256 monthly if the young adult remains in foster care but temporarily resides away for attendance at the post-secondary school. So they can go away to school too. Established room and board rate for foster parents if the young adult resides in licensed foster home and is attending post-secondary school. If he remains in foster care but is in licensed group home, the amount is negotiated between the community care lead agency and the licensed group home. Again, if the young adult resides away temporarily while attending school, then the amount is $1,256.
I just have a good question. For, say
adult is going away to college, is room and board covered at the university, or does that, you have to find boarding from that 1,200?
I think it's going to be negotiated
Negotiated, okay.
by the community care agency. What's the catch? The amount of the award may be disregarded for purposes of determining the eligibility for or the amount of any other federal supported assistance. In other words, these kids are going to be getting possibly athletic scholarships, grants, federal grants, things of that sort. You want them to apply for as much assistance as they can get. PES continued. If the child chooses not to remain in foster care and is attending post-secondary school, then the community care lead agency gets the money in order to secure housing and utilities for the young adult, with the balance going to the young adult. Note your prohibition. The community care lead agency is prohibited from charging a fee associated with administering the Road to Independence payments. Okay, the next statute is 409-1451-3, the aftercare services. These are for those not in foster care, for ages 18 to 22, and for those not getting financial assistance for post-secondary education. You may have a lot of these kids because a lot of the kids don't want to go to school. This includes, but is not limited to, mentoring, tutoring, mental health services, substance abuse counseling, life skill classes, credit management and preventive health activities, parenting classes, job and career skills training. Everything's listed in the statute. Counselor consultations, I'm not sure what they mean by that. Temporary financial assistance for necessities. Necessities is listed as education supplies, transportation expenses, security deposits for rent and utilities, furnishings, household goods, and other basic living expenses. You can go crazy filing motions for these things. Remember, these services are for those young adults that choose to leave foster care and must be applied for. Don't let these young adults fall through the cracks. This is interesting. Aftercare services, how are they determined? And the statute states by assessment of the young adult, and may be provided by community care-based provider or through referrals in the community. Does anyone know or has had experience of when this assessment is done and by who? In the back.
Well, I've had a hard time getting the aftercare services from one of the CBCs that I work with. They've said that they will only use it as an interim for kids that are on their way back into extended foster care, that it's a bridge program for them. And
I don't think the statute says that.
I didn't think so either. The person that I spoke to about it is the person who was the assigned independent living coordinator at the CDC. What I ended up doing was challenging her on that. What I was told was that the kid should put in a request, it could get denied, and then I
Right, which is the next subject I was going to cover, was the appeal process in a minute. How much time left do we have?
Just a couple more minutes, so not breeze through.
Okay, do you want to cover that in section, or do you want me to keep going with the judicial review and appeals?
Well, do you want to just go through that? They probably know that, what happens with JR when they get ready to age out documents. You have to provide the children, all that. Y'all are familiar with that, right? Because that's all presiding for it. I can go ahead and skip through that. And we'll get on to guardianships.
Yes, let's go ahead and move on to guardianships. There is appeal process in the PowerPoint, the statutes that apply to it. In the PowerPoint, there's also information on the judicial reviews for the children that are out of foster care or in extended foster care. So Baldry wants to cover guardianships, which is important. So we're going to go to that.
How long are the aftercare services aged? I've only seen them when they kind of transition the child to be living on his own to help him out. But how long can they have those aftercare services, the ones they talk about therapy?
I think the statute, the statute says up to 22. Yep, for young adults 18 to 22. Okay, Baldry? I hope that was helpful to some of you.
Okay, at the end, I just wanted to talk about long-term transitional planning regarding guardianship, guardian advocacies, and guardianships through probate, mental health, and guardianship division. These are the long-term guardianships that will go for the people when they for the most part, when they turn 18 and above long-term in the future. There are two types. There's a guardian advocate, a procedure for developmentally disabled kids who are aging out. That's under Chapter 393. And what are the criteria for that? Those same APD designated disorders that we talked about. They're the same. And you have to prove one of those for a guardian advocacy to be set up. Now, the other standard kind of guardianship can be limited or plenary. That means either some of the rights are removed and others left intact, or plenary means all the rights have been removed under Chapter 744. Interestingly, I don't know if this is a new statute, dependency court still has oversight of this for young adults in extended foster care. They're supposed to review this at the permanency hearings. And we'll review the necessity of continuing the guardianship and whether restoration of guardianship proceedings are needed when the young adults reaches 22 years of age. This probably isn't going to be considered very much if they're under Chapter 393 because they basically got a lifelong developmental disability. But it may come into play. I mean, if you've got a young adult in extended foster care who maybe was in a psychosis or something, or incompetent based on drug or alcohol addiction, they may come through it with rehab and they might be eligible. You may want to look back out and see if in a suggestion of a capacity or restoration of rights. But those are very hard to prove. I've been involved in one of those. It's kind of hard to unring that bell. You've got to it's a hard standard of proof. Now, can you, as special needs attorney ad litem in dependency court, become a petitioner for a guardian advocacy or a guardianship in those separate proceedings? And I've struggled with that because some of the attorney ad litems said, well, if they want you to do that, if they want you to petition, you can. And then others said, no, you can't. So I want a clarification of that, so I called the state bar. And they said, no, don't get yourself in that situation. Because if you think about it, basically you're removing rights of your clients. It's kind of an inherent conflict. And here's the case that the state bar cited, and that you shouldn't be involved in that. I think there's another new procedure called a guardian advocacy voluntary petition, and I wouldn't go there either. I've never seen one of those, but that may be something we'll be seeing more. But does your client even have the capacity to file one of those? I don't think it's smart to get involved in it that way. However, if your client does support it, I think you can facilitate it, but you can't file it for them. You can recruit a petitioner, someone with personal knowledge. My last one was an APD support coordinator who did that, was very familiar with my client. Recruit a qualified guardian advocate or guardian who will hopefully your client will be comfortable with and can afford or will work pro bono. Your number one resource is the Office of Public Guardian. They don't charge any fees to do now guardian advocacies and 744 guardianships. As of, I think before July 2016, they were prohibited, they weren't authorized to be, to have guardians and guardian advocacies, but that all changed last July, and they can do both now, which is a tremendous help. They usually have a very long waiting list, but with my cases, they've said if you can recruit an attorney for the petitioner who will agree to stay on it indefinitely, we'll take it and we'll provide a guardian. So that's been great. I also have a great success story, a long-term guardian ad litem for one of my autistic teenagers. Actually has taken the guardian advocacy training and is going to resign as her guardian ad litem volunteer and become her permanent guardian advocate. And it's just wonderful. And of course my client feels they're very comfortable with her and they're very close. It's a win-win situation. Relatives, if not disqualified, or referrals from third persons, know about people who would possibly serve. Now, in both of these proceedings, your youth is going to have a separate attorney appointed to him or her in the GA or the guardianship proceeding. You can collaborate and give information to that person. All right. Now you need to, if you're a special needs attorney ad litem, you need to advocate for your client's wishes if they can communicate them. If they don't want it, you should object and not facilitate a petition filing. You should kind of explain to them the process that they'd be giving up some or all of their personal legal rights. You can even go through the specifics with them, and that it would be very hard in the future for that to get changed and restored back. They'd have to bring a suggestion of capacity restoration of rights. It was funny, I was in a guardianship hearing and my magistrate said, I think because part of his restoration petition got denied, and he was like, he can file one every week if he wants to. So I was like, well, that's good to know. He's got due process going on. Who can tell me any differences or common elements between the 393 GA and the 744 guardianship? Yes, sir?
Well, guardian advocate's much simpler. Has to be intellectual disability or whatever.
One of the APD designated disorder.
APD, whatever, one of those 6 categories before 18, you don't need the examining committee.
Thank you. Anybody else? Yes, ma'am?
No lawyer needed if you're just a guardian advocate versus you need a lawyer, legal representation as a 744.
Right, it's a lot more complex, yeah. So, that's wonderful. Y'all are really on the ball here. That's great.
And a guardian advocacy, you don't have to do an annual accounting, you can show that the money is from Social Security.
Just SSI, yes, that's in the statute, I believe. Excellent, excellent, excellent. Y'all pretty much stole my thunder. Yeah, that 393 is the preferred, less restrictive alternative guardianship, that guardian advocacy. And that goes through the qualifications there. And you don't need the adjudication of incapacity. Just that the standard is the alleged ward lacks decision-making to do some tasks necessary for his or her personal property care. I've said that, and just like you were stating, in the regular guardianships, you've got to have an adjudication of incapacity for the adults that the AIP, the alleged incompetent person, lacks capacity to exercise legal rights based on any disabilities. But that can be on any other grounds too. It's much more expansive, and so sometimes you have to go that way if they don't meet the criteria under the 393. More restrictive, some or all rights can be removed. You can do that for minors. And for that for that 744 for minors, I don't know when you would probably need to do that for DCF kids, but no adjudicatory hearing required and no examining committee in that particular circumstance. And he was talking about you need the The 3-member examining committee on the 744, they each do a full independent report. Right now, they get paid if it's court-appointed $300 apiece. You got to evaluate those reports. Those will come into evidence at your guardianship proceeding. You got to have a physician statement usually. And that 393, like I said, is a lot more simple. No examining committee required. Very liberal proof of the ward's disability permitted, like IEPs, disability program records. I've submitted APD records. Dependency court reports have sufficed. Any of that can be attached. I think what she was saying with the 393 guardian advocate, it's usually less stringent accounting procedures with that, lot easier. And they're usually family members who bring the parents or other family members who bring the 393. On both of them, there is a personal history credit check. They want to make sure your guardian or guardian advocate is a person of good moral character. 744, more stringent detailed annual accountings, and I found in them it's harder to get that guardian bond waived on those too. They usually will waive it in the guardian advocacy, but not in the guardianship. And of course, that depends on the amount of assets in the guardianship estate. And the standard by which you need to prove these things is by clear and convincing evidence. Petitioner must prove a lack of decision-making in a guardian advocacy or must prove incapacity on one or more grounds in the guardianship proceeding. And here are under the chapters, the specific rights that are possibly delegable to the guardian advocate or the guardians that can be removed or retained, and you can read about those. And here are the rights that can be removed but cannot be delegated to the guardian or guardian advocate. And that makes sense. It would be hard to delegate any of these things. So anyway, coordinate with your child or young adult about these issues and about attending the hearing and dealing with their appointed attorney in that separate proceeding. And plan to present any non-privileged evidence and testimony to support your client's retention or non-removal of specific rights. Or at least ask for the judge or magistrate to include language that they should at least have substantial input and be involved and consulted in detail regarding the decisions closely with their guardian. Just explain to them as well that this person will be accountable to the court to make sure none of their funds or assets are mismanaged. Now, this is very interesting. You also need to investigate all possible disqualifier facts of proposed guardians who may petition, because what I found is these, for my extended foster care kids or ready to be 18, their TPR parents and other unscrupulous relatives come out of the woodwork to contest it and all of this stuff. So you got to ask your client, what's the position on that? But it's really scary, because we think the motivation would probably be that they want to get a hold of the funds, that that's their motivation. But the statute helps us there. Some of the applicable disqualifiers for people to be appointed guardian advocate or guardians include convicted felons, designated specific crime criminal convictions, ill or incapacitated persons, in general unsuitable persons, and most importantly, a person who has been judicially determined to have committed abuse, abandonment, or neglect against a child, which is really helpful there. Fortunately, under the statute, unsuitable TPR parents and no-contact relatives are disqualified on these grounds, and let the judicial system sort that out. So you got to go back in, and if your child doesn't want them to be it, and they've filed a counter petition or are going to appear at the hearing, provide supporting documentation and certified court records to the petitioner, petitioner's attorney, ward's attorney, and other parties, and use them if necessary as evidence. But in my recent case, it was interesting, because what's going to happen when you look back through the dependency file, you're going to see that that parent entered a what at adjudication? A consent. So is that a judicial determination? I was ready for the attorney to come and argue that, which I might have a valid argument on that point. So you may be out on that with your certified copy of the adjudication and disposition. And what's bad about the convicted felons is if you read the details in the statute, if there's a withhold of adjudication, guess what? That doesn't count. Now, but you go into these really cool specific crime criminal convictions, which are like fraud and criminal conviction for sex abuse, abuse on children, all this stuff. And those, it doesn't matter if there's a withhold of adjudication or not. The statute specifically says that doesn't matter, and those will disqualify your squirrely person coming in. As a matter of fact, on mine, all of his felonies, there were withholds of adjudication. So I went back under this other statute, and sure enough, he had a solicitation for prostitution conviction, and that he was out, so that was great. I was thinking about this last night with this unsuitable persons kind of catch-all. What else from a dependency file do you think you could present at this guardianship hearing to get them disqualified? Can you think of anything else? That may be a judicial determination, that's the hint. Yes, ma'am?
We use the shelter, the fact that the child had been removed based on abuse, abandonment, or neglect, made them unsuitable, and then the ultimate finding of dependency.
That's a good point, yeah, because you've got a judicial order on that. That's good. And then I was thinking you could argue, even looking at judicial reviews, if they haven't complied with their case plan, that makes them unsuitable, don't you think? So pull it all out of there. Get creative on this. You're also going to need to investigate all the current funds and assets of your older youth. I think I talked about that other presentation about you may call up your master trust person and she goes, oh, but by the way, we've got an extra $12,000 in dedicated trust in a sub-account, and you've got to find all that out because that's going to have to be dealt with and go over to a special needs trust and the guardianship or an ABLE account or something that won't offset that SSI. It's all about sheltering that SSI monthly benefit. You want to make sure. I'll talk about that too. Oh, now in your OPG, they are really up to date on all these sheltering trusts and things, and they're great resource if you're not really into that area. So, okay, got my Georgia Bulldog in here, guys. I had to do it. So anyway, now here's a tip that I picked up on. I've been working with our local OPG office. If your APD application has not yet been filed and you think you're going to file one, or it's pending and you don't have the determination back, you may want to wait for the APD wait list final approval before filing that guardian advocacy or guardianship, because that may affect your client's eligibility chances. They'd be viewed as less at risk, less of care needed if they've already had a guardian appointed, and may decrease the client's benefit services. I really haven't discussed that with the APD, but according to OPG, they're like, see if they can get that done first, because once they get a guardian, they're going to be looked at, they really don't need us as much, so, for whatever that's worth. So I'm trying to do that in one of the cases. Now, in the guardianship or guardian advocacy, I have in the past, I couldn't file the petition, but because I have personal knowledge of the client's indigency and their financial assets, to waive court costs and other court-related fees, you can, I believe it's appropriate. I filed an affidavit of indigency for my client here and stated all the grounds. And remember, the OPG needs specific language too, and they'll give that to you if you're asking for them to be appointed. Now, I've also included a petition for appointment of a guardian advocate that was done regarding one of my special needs kids. And it has some extra stuff in there that I think is good. You want to give all parties in the dependency court proceeding notice of this. I even email copies to the magistrates and the judges that are dealing with the case, so they know this is getting done, they're off your back. So that's a little different. And you know, in most of the guardian advocacy petitions I deal with too, they still go through those same specific rights as they do in the as they do in the 744 guardianship. And it's good because it keeps it very clean, what specific rights, you know, are going to be removed, what's going to be retained. And you can you can go over that with your client. What time is it? Oh, that's about right. Okay, in conclusion, okay, so that gives you an example there. In conclusion, try to avail and advocate for all available and appropriate programs and services for your special needs youth. You will sleep better when you feel your older youth has all available services with effective ongoing advocacy. Your young adult, your ward, in the preceding example, has extended foster care case manager, has an APD case coordinator, substantial ABA services, and a ABA caseworker with her for many hours during the week when she's not in school. She has a Chapter 393 guardian advocate, Aging Solutions, OPG. She still has her guardian ad litem attorney, the guardian ad litem volunteers agreed to stay in, the state attorney, and me as her special needs attorney ad litem. And that's it. So we're pretty good on time? Okay, great. Okay, does anyone have any questions, or they want to come up afterwards? I know it's Friday afternoon. No questions? All right, thank you all for staying. It means a lot to us.